In Circleville, Ohio, about 45 minutes due south from Columbus, Ohio. Sofidel, an Italian paper manufacturer, operates a paper products manufacturing facility, making rolled consumer paper products like paper towels. In September 2022, two workers entered into a giant rewinder machine to clear a jam. One had his hand near a pinch point when his coworker, operating the control panel, put the machine into reverse jog. The first worker suffered a hand injury. The injury was severe. OSHA issued citations under the Lockout Tagout standard. Today, we'll discuss the judge's decision and its implications for all employers. I'm Manesh Rath, and this is the May 2025 episode of the OSHA 3030. Well, welcome everyone to the OSHA 3030. I'm Manesh Rath. I'm an attorney at the law firm Keller and Heckman here in Washington, D.C., and for 30 years I've been engaged in representing management side in the field of occupational safety and health law, amongst other areas. I'm grateful today because I'm joined by my good friend and colleague, Ben Idzik. Ben, welcome to the OSHA 3030.
Great to be here, Manish.
Well, it's great to have you here. And Ben, I think we have an important subject, and it's one of those issues in the field of occupational safety and health law that can be read two ways. It confuses some people. It certainly creates an opportunity for debate amongst a lot of people. I think we should talk about it. This is the citation involving Sofidel America versus the Secretary of Labor. I think to start off with, we should talk about the elements that OSHA has to establish when proving a violation of a specific standard.
Yeah, always important to get that background, and then we can get into the particular allegations that OSHA made in this case.
Right, those are OSHA's allegations. And then to give both sides of the story, we should also talk about Sofidel's defenses before the administrative law judge.
Right, and then finally get into the administrative law judge's holding in the decision.
Right, and that's really the important part. Sofidel ended up appealing
Mhm.
the judge's decision, so we're going to talk about that real briefly. And then finally, as we always do, we'll wrap up with some practical takeaway items for you in the OSHA 3030 community on a slide titled What Employers Should Do, what they should do in light of the Sofidel decision. So let's first talk about the facts of the case.
Let's do it. So we are going to be discussing Sofidel America, which is a subsidiary of Sofidel Group, which is a large multinational company based in Italy, and it specializes in manufacturing disposable tissue paper products like toilet paper and so
And
forth.
paper towels, right? A lot of it, if to the extent that it's household names, they're household names for their European markets. And in the United States, a lot of private label work that they perform for institutional clients.
Right. That's exactly right. And like you mentioned, the facts here center on a machine called the R88 line Gambini rewinder. The machine, what it does is it unwinds large rolls of paper that are then sent down to other machines for processing into the final products that we just talked about.
Right. This is a large machine that handles huge volumes of paper at high speeds, and it also requires its own electronic circuitry for all of the operational modes, and it has its own housing around the rewinder. And you make a good point. It's called a rewinder, but it's also used for storage and unwinding. This particular machine that was involved in this incident was unwinding paper onto another spool.
That's right. The important thing here is that the unwinder or the rewinder machine, the R88, it jammed very frequently during processing, usually at least once an hour.
Sometimes multiple times an hour, depending on the product, right?
Right, exactly right. And when these jams occurred, there was a computerized system that would stop the rolls from operating, but the machine itself remained energized.
Right. And what the process that they used for handling this was there were multiple different options, but there were jog options for jog forward using a control panel. There was jog forward using a dead man switch.
Mhm.
And then there was a reverse jog, which only could be done by the control panel.
Yes, that's exactly right. And if these jams, these routine jams, couldn't be cleared by operators using these functions that you mentioned, Manish, then Sofidel had specialized employees called tuners that would then come in and apply lockout tagout procedures and perform, I guess, more detailed maintenance.
Yeah, at that point, once it's locked out, the unwinder or the rewinder could be unjammed by hand. However, while it was in jog mode, reverse or forward, the process involved rolling the rollers forward and backwards until the jam kind of spilled out.
Hmm.
Much of the time, almost all of the time, the product that was jamming the rolls could be spilled out from between the rollers simply by rolling a little bit forward in jog mode, a little bit backwards, and then the jamming product material could be cleared off the floor. It would fall to the floor and could be cleared off there. So it was theoretically possible for an operator to unjam the machine while standing at the control panel. Now, here's an important point about this particular machine. The control panel was at a great distance from the rollers,
Yes,
so they would have been outside of the zone of danger, provided a worker was operating the control panel.
that's exactly right.
If they were closer to the machine, they would operate the jog mode using a dead man's switch.
Hmm.
Thus, if there was any problem, letting go of the dead man's switch would immediately cease the jog mode. So that was the method that Sofidel used and believed was safe for workers, there being no exposure, provided that an employee was only using the control panel to go forward or backward in jog mode.
That's exactly right.
Okay, let's keep going. So this is, I think, an important uh, process design that members of the OSHA 3030 have to understand in order to understand why Sofidel had the process, the procedure it had as it did. One of the things about the machine is this control panel was inside the housing.
Mm.
And so to enter the housing, there was a interlocking door,
Yep.
and the minute the interlocking door was open, the machinery was de-energized. Then the employee would go to the control panel and operate it in jog or reverse jog.
Right. Right. So when Manesh, like you mentioned, when the employees would come, when the operator would enter the machine through the interlocking door, there started the process of trying to unjam the machine, which you mentioned involved using the reverse jog, the jog function, and the aim was to get the machine to a position where the employee is able to remove the jam by hand, which is where landed some folks into trouble in the cases here.
Right. If they had put the machine in to jog forward using the control panel, there was an audible alarm, went 3 times,
Yes.
and then the machine entered into jog mode. It
Yes.
was very slow. But again, the operator should have been in at the control panel.
Yep.
And in order to make sure that that system sufficed to keep that worker out of the zone of danger, there was an administrative rule.
Yeah, an administrative rule is that only one employee was permitted to go into the machine to clear their jam. And like we discussed, the idea was that you didn't want to have two employees entering the machine because one could go into the control panel and the other could go into the roller machine.
Zone of danger.
Right, and there could be a problem that occurred then with one person activating the jog function and the other person having his hands near or on the rollers.
Right. The belief was that by design, the distance between the control panel and the zone of danger was sufficient so that if you had an administrative rule that only one person was in there, the machine would have been de-energized while the interlocking door was open. And then when the employee was at the control panel and re-energizing it into jog mode,
Mhm.
he would have been away from the zone of danger. This requires, however, that administrative rule
Right.
that there be only one person inside the machine at a time. If you have a second person who slips in when the first worker keys his key card to open the interlocking door, and yes, I believe it was key controlled,
Yeah.
then another person slips in, that is a violation of Sofidel's rule
Mhm.
and creates the possibility that a second employee could be at the zone of danger when the first employee was operating the control panel.
That's right.
And
That's
that's
right.
precisely what happened.
Exactly.
Okay. So OSHA comes in, does it, well, I should point out that's precisely what happened. And in this case, worker number two operating the control panel put the machine into reverse jog,
Mhm.
while, as you say, the worker number one had his hand in the zone of danger, was caught in a nip point and suffered a severe hand injury, a degloving injury, and was uh, rushed to hospital. And then from there, medevaced to another hospital that had specialists who could attend to this rather severe and highly involved injury. He didn't return to work until much later.
Right.
Okay, so that's the basic rundown of the facts of the case. Um, Now, Sofidel reported to OSHA the injury.
Yep. As they were required to do under the OSHA health and reporting rules.
And OSHA comes in, conducts an investigation. They issued 6 citations,
Mm.
mostly under the lockout tagout standard. 2 of them serious violation allegations.
Yeah, and the two serious allegations are the ones that are at the heart of the dispute here before the LLJ.
Right. Can you walk us through those 2 citations? What were they for?
Yeah, so the first one was the citation under the lockout tagout for not requiring employees who went in to clear the jams for these machines to apply lockout tagout procedures. And the second was very related. It related to the fact that Sofidel didn't train employees on these procedures. And like you mentioned, the Sofidel contested timely these citations within the 15-day working period, which led to the ALJ's decision in the case.
I think that you'll almost always see a training allegation of a violation in these lockout tagout cases because it's easy enough for a compliance officer, if they interview enough employees, eventually one employee is not going to recollect that they received the training,
Mhm.
or they might say, yeah, I might have received some training, but I didn't understand it. It wasn't very clear, something to that effect. And once you get a single testimony, the compliance officer may have a basis for alleging a violation of the training standard, even if in fact there was no violation of the training standard, because it requires highly unreliable witness testimony of employees who don't have a motivation, strong motivation, one way or the other, to say, yes, I received training and I didn't operate the machine that day in accordance with my training. I knew I was doing this the wrong way. And that's not something that a witness is strongly motivated to testify to a compliance officer. And
Mhm.
so it's easy for a compliance officer to get a unreliable, albeit supporting testimony from a witness saying that they weren't trained or they weren't properly trained. And that's why I think that you can expect the training subsection of the lockout tagout standards to appear in the list of alleged violations when there are lockout tagout cases.
Mhm.
And I think that's unfortunate. There has to be a method by which employers can protect themselves from these maybe inaccurately formed conclusions by the compliance officer. And we want to talk about that on the last slide.
Right.
So remind me to address that as well in what employers can do. Okay, so 6 citations. Now, these are citations of a specific OSHA standard, in this case, lockout tagout. So the lockout tagout standard. So let's talk about what OSHA has to prove when alleging a violation of the lockout tagout standard.
Yeah. So as a baseline, the burden of proof is on OSHA, and they must prove each of these four elements here by preponderance of the evidence. So we first start with the showing that the standard does apply to the cited condition.
Yeah, and one of the problems with lockout tagout standard is there's a really critical exception, the minor servicing exception. And if the minor servicing exception to the standard applies, the standard does not apply. It is an exception to the scope of applicability of the standard. And so that becomes a debate, a central debate between Sofidel and OSHA.
Exactly right. Exactly right. And the second element then is that the terms of the standard that it applies were violated.
Right. One more element is that the employee or any worker, the employee who was injured or any worker had access to a hazardous or allegedly hazardous condition.
Right. And then the final element is the knowledge element. The employer either knew about the violation or should have known with reasonable diligence that it applied.
Right. And they debated that particular element in this case. And I think the administrative law judge focused on some elements that the agency alleged Sofidel knew. But Sofidel was really arguing that there were other elements of the fact pattern that it was unaware of.
Mm.
For example, the two-man entry, if I'm not mistaken.
Right.
So that's the elements OSHA has to prove. Let's talk about OSHA's allegations specifically. The first, and you ran through these, Ben. The first is an allegation that the machine was not de-energized, but should have been when the employees were conducting jam clearing.
Right. And this OSHA relied heavily on the language of the standard, which says that the standard applies when the control of energy during servicing or maintenance and equipment in which the unexpected energization or startup of machines or equipment can cause injury to employees. So that's sort of precisely what happened here is that in OSHA's eyes at least is that these two employees went in for servicing and for maintenance, and they were by doing that exposed to the release of stored energy because the machine was not de-energized.
Right, that's right. OSHA is essentially alleging that this should have been locked out when they conducted their unjamming process, and Sofidel isn't arguing that it was not de-energized or that it was. Sofitel is arguing that in the first place, this was a part of their regular operations, and in the second place, this was a minor servicing exception
Hmm.
kind of activity. And because it happens, as you said, Ben, sometimes 4 times an hour, but at
Hmm.
a minimum once an hour, depending on the specific product that they're running through the machine. And
Hmm.
that's so frequent as to become a part of the routine manufacturing process.
Yeah.
So that's their argument for the minor servicing exception, and thus that, yeah, it wasn't de-energized, but it didn't need to be. It didn't. That wasn't a failure in their
Hmm.
compliance with that requirement. Um, okay, so that's OSHA's allegation. Sofidel's defenses?
Yeah, so like you just mentioned, I think really Sofidel's main concern is the fact that they saw that these jams happened so frequently that you couldn't really call that servicing or maintenance that triggered the lockout tagout. Um, they in fact pointed to their policy in which when jams occurred on the R88 and the jam could not be cleared by regular operators, they would then send out specialized employees called tuners that were trained in lockout tagout procedures and would in fact lock and tag the machine to then resolve a serious jam. But again, their focus was on the fact that because of how routine these jams were on the sort of hour by hour, the operators themselves weren't subject to the standard.
Yeah, and that really leads to the crux of the debate between OSHA and Sofidel, and frankly, a lot of employers share Sofidel's view as to where minor servicing applies and what constitutes maintenance. In on the face of the standard, as you pointed out, Ben, maintenance includes unjamming. It's expressly listed in the standard.
Mm.
But when it becomes something that fits the minor servicing exemption, it may still be an unjamming activity and not the unjamming that's described in the maintenance section of the standard.
Right.
That's just not, frankly, clearly laid out in the standard. The administrative law judge thought that it was laid out very clearly.
It certainly did. It certainly did, and that's sort of where I think the decision came down to is that that the ALJ found that even though the machine was stopped automatically, it remained energized, and thus, as plainly stated in the standard, like you mentioned, exposed employees, these operators that would go in to clear the jams, to this release of stored energy from the machine.
Right. And so that goes to the question of locking out. I think the other problem that Sofidel raised was that unjamming has to take place while the machine's energized, because you have to put it into jog mode, forward and reverse, to release the jamming material.
Hmm.
And and I think that that is again a commonly shared belief amongst manufacturers using equipment similar to this in paper and forestry and lots of other industries that have roller type equipment
Hmm.
um, or any other kind of equipment that is subject to frequent jamming.
Hmm.
And these jog modes are extremely slow. They would not result in an injury. The problem is that the second worker put the machine into reverse jog, which A, did not have the audible warnings,
Hmm.
and B, I got the impression that it was not as slow a jog mode as forward jog.
Hmm.
And if that's true, then that may be a hazard that's distinct from the kind of hazard in forward jog mode. Okay. The other argument that Sofidel had made was that this, to the extent that there was any exposure that could have been addressed by the lockout tagout standard, this would have qualified as unpreventable employee misconduct. Sofidel argued, after all, we have a policy that only one person should enter, and if one person had entered in compliance with that rule, there wouldn't have been this injury. There's no way there would have been this injury because the operator would have either unjammed using the dead man switch or the control panel, and the control panel is well outside of the zone of danger for the rollers.
Hmm. And I think the problem that the ALJ found with this argument is that he wasn't convinced that Sofidel actually applied this policy consistently. OSHA presented evidence that um, uh, employees would engage in this conduct fairly frequently, and thus Sofidel couldn't claim that as a protection from citation.
Yeah, that's unfortunate. One of the two employees involved in the incident testified to the compliance officer that he frequently did two-man entries with another worker, and that he believed that his supervisor was aware of that.
Mm.
That is, to me, strictly speculation and should be barred from admissibility It's poor quality evidence that should be inadmissible. And to the extent that he is looking at the behavior of the supervisor to indicate what the supervisor thought or believed, that would also be objectionable under the hearsay rule, which, Ben, you know, is a complicated rule. It lives within its exceptions to the rule. But this certainly would, to me, qualify as classic hearsay to the extent that he gleaned this conclusion from any behavioral communication by his supervisor rather than an express articulation of an understanding by the supervisor. Now, what did Sofidel say expressly its belief was? Well, that's more interesting.
Mm-hmm. And I think this is going to be an issue that when the appeal
Yeah,
raises up, this is exactly what,
they articulated very clearly, I think, in their appeal
yeah,
brief, right?
exactly.
They said in their appeal and into the lower court, their policy was to enforce against violations of the two-man rule. They had several incidences prior to this instance where people had violated the two-man entry rule and were terminated. And that's proof that they, A, prohibited it, B, clearly communicated it, and C, enforced their rule. OSHA's response was that, well, we hadn't done that since 2019. And Sofidel's response to that was we hadn't had any violations of the rule since 2019, which is proof that the rule was uniformly applied and that everyone understood it. This is an interesting back and forth, and I think it really does probably require a trier of fact to come down on one side or the other. But there's no getting around, and certainly OSHA does not deny that Sofidel had this rule and had terminated two other people. Indeed, one of these two workers, the one with the injury, was terminated upon his return.
Mm-hmm. I think just a little problematic for Sofidel on this point is that it was terminated, but it was only after the citation was issued.
Yeah, that's what OSHA argued, but OSHA has 180 days to issue a citation, and they may have issued this rather quickly after the event. But Sofidel terminated the returning employee immediately upon his return.
Mm-hmm.
His injury was severe, and his absence was a significant one. So it's not Sofidel's fault that a citation was issued and then he returned and was terminated. For them to allege that, well, you only terminated him after a citation was issued is not to the point. Mm-hmm. If he was not an active, on the schedule working employee, then there was no urgency for them to have taken their administrative responsive action of terminating him. And I think that is, on OSHA's part, an argument that is strictly conjectural and frankly highly cynical. Nobody knows what their motivation was when they terminated him except this. It is indeed consistent with the fact that they terminated a couple of other employees years ago for the same violation. That fact is immutable, and OSHA's conjecture as to what Sofidel's motivation was is cynical, and I don't think it should be taken into account or given any weight by the appellate court. But yeah, that's a great point. The problem for Sofidel could have been alleviated perhaps by terminating immediately. Even while he was rushed to the hospital, they could have effectuated paperwork that terminated. They could have communicated it when he was ready, but there's certainly nothing stopping them from terminating an employee, even though he's in hospital. Okay, let's keep going. So this matter, as you say, has been appealed. Sofidel filed an appeal.
Yep, they filed an appeal, and that was before the ALJs, before they petitioned the full Occupational Safety and Health Review Commission for an appeal of the ALJ's decision. The commission as a whole declined to hear the appeal, so that the next course of action makes the ALJ's decision a final order, which then is appealable to a judicial court.
That's right, that's exactly what Sofidel did, and the appeals has been filed before the Sixth Circuit, U.S. Court of Appeals for the Sixth Circuit. That is roughly the Ohio, Indiana area, and it's already been fully briefed, and I believe it's been heard. Is that correct?
So I think Sofidel raised the request for oral arguments. Both sides have submitted their briefs. I think OSHA submitted their brief earlier this month on May 9th. So it's before the court. There may be a hearing on it, and we certainly will stay on top of it.
Would expect to hear a ruling on this probably in the next month. Would be a reasonable expectation. And when it happens, we should mention it again, maybe pick up another episode of the OSHA 3030 on the appellate court's ruling, because I think First of all, on the specifics of the lockout tagout standard, this is an important case.
Mhm.
The intersection between maintenance and minor servicing, the utility of administrative rules, the exposure question, which goes to the zone of danger, and the unpreventable employee misconduct defense are four critical points that all employers should know about. Those involved in lockout tagout, which is virtually every employer covered under the OSHA Act, as well as the unpreventable employee misconduct defense, which applies to every single employer covered under the OSHA Act. And so I think that this deserves to be another episode of the OSHA 3030 when the Sixth Circuit opinion comes out.
Yeah, you do.
Okay, let's talk about what employers should do. Well, I put a marker down to remind me later on, and I want you to discuss that in a moment of one of the critical points that we want to talk about. But I think the first critical takeaway item for the Sofidel case is that employers should evaluate the duties assigned to employees and whether the tasks being performed by those employees would implicate a specific OSHA standard, in this case, the lockout tagout standard. Uh, I think that the point here goes to the fact that there were operators of the machine, they were referred to as converters, and then there were tuners who would have come in and performed any more involved work that would have involved exposure to the zone of danger, and they would have performed lockout tagout functions.
Yeah, that's exactly right. And I think the if Sofidel would consider the operators to be subject to the standard, then this situation would have been avoided, which is exactly why, like you mentioned, it's important to evaluate these duties to see what standards may come into play.
Right. I think the other thing that employers need to do is to conduct walkthroughs, gambles, and make sure that they are monitoring for compliance with their rules
Mhm.
and issuing warnings right then and there if there are violations of the rules so that they have a record. And I think that there needs to be a written record, by the way, that the warning was issued verbally. There's no such thing, in my opinion, as a truly verbal warning or a verbal disciplinary action. Everything should be memorialized in writing so that it is also effectively a written warning or a written disciplinary action. If you don't take that step of monitoring and taking immediate remedial action, then I think that you've missed the opportunity to use the unpreventable employee misconduct defense effectively, because that is a critical ingredient to the unpreventable employee misconduct defense.
Mhm. Consistency is definitely the key.
Right. Now, the one that I pointed out earlier in our session that I think we ought to talk about is training. I said that earlier in our episode that training is going to show up, training alleged violations, or it's going to show up in a lot of lockout tagout cases. And the method by which the employer can protect themselves is to conduct training where the material is preserved for the record, the sign-in sheets are preserved for the record. For lockout tagout, there needs to be testing to test for comprehension. There should be witnesses for performance tests, multiple witnesses to say that the employee did it properly. There should be written tests, and written tests should be preserved on a per employee basis, as well as the attendance records. And if you have all of those recorded and an employee testifies to the compliance officer that, oh, no, I don't think I was told how to do this particular element of the lockout tagout process. In this particular case, it was the no two people entering the equipment at one time rule. You would have had all of the material I just described, and they would have been specific to that rule as well as to other elements of your lockout tagout procedure. For example, there could have been a written test question on that rule. There could have been a slide in the training materials discussing that rule. There, of course, you'd have standard operating procedures, and every employee might have signed off on. So that's a fifth element of proof of training, signed off on that standard operating procedure. And then the witnesses would have signed off in the performance-based testing that the employee only entered one person and didn't enter using two people. And those are all vehicles through which the employer can protect themselves against some element of an inspection that you really have very little other protection against, which is the employee's testimony that says, oh, yeah, I don't know if I was trained on that point. I've never heard that rule. Nobody ever told me that. That is, again, something that an employee does not have a lot of motivation in the moment that they're being interrogated by a compliance officer, does not have a lot of motivation to tell the truth. Indeed, I was trained how to do it right, and I didn't do it the right way. It happens sometimes that an employee tells the truth, not as frequently as I would like. And these are the instruments that can be preserved on record that would help protect and mitigate the damaging effects of inaccurate testimony at the time where the employee may not be thinking clearly enough about the importance of truthful testimony.
I think you said it excellently well. The point is that documentation is key. Like all these things need to be documented
Right.
because if it's not documented, then like you mentioned, there's no definitive proof that you can then later assert to OSHA.
Right. Documentation of your standard operating procedure, documentation of the training, and documentation of the monitoring and any reprimands, verbal warnings, etc. Finally, I think with specific regards to the lockout tagout standard, at least for now, the judge in this case has evinced an belief that unjamming in such equipment does not constitute minor servicing, and that the fact that the machine was energized at the time qualified in the judge's opinion, the administrative law judge's opinion, as a violation of the lockout tagout standard, suggests to us that at least for machinery that is capable of being locked out to be unjammed, that de-energization should be a part of the process. I'm persuaded by employers in this particular space that energization is required for unjamming rolling type equipment like this rewinder, because the jam is inside two in running rollers, and the only way to get the access to the machine, to the material that's jamming, is to unroll those rollers, maybe in reverse jog or in forward jog, and let the material fall out to the floor harmlessly without any employee exposure. But to keep a jog mode level of energization seems to me to be critical. Perhaps there are employers who have machinery, the circuitry and control for which permit additional protections while the machine is energized, but but the control circuitry permits of jog mode. There may be other protections, and I would certainly advocate for those additional protections. But I am persuaded that energization for machinery of this type, the rewinder, seems to me to be the most effective way to unjam machinery, and thus other methods for protecting the worker need to be explored, and that it's not as simple as saying that the machine has to be de-energized 4 times an hour potentially when anytime a jam occurs.
Mhm.
Okay, well, that's today's OSHA 3030. Ben, thank you for joining me on this, and I'll point out a few other critical points. This program will be republished as a podcast, and you can pick it up on your favorite podcast app. It'll also be published on our website with the video and audio for the slides, so you can pick it up. It's housed on YouTube, and you can listen to it there, and all of our prior episodes as well. And when, please, this is a program that we do complimentary for friends of Keller and Heckman and clients of Keller and Heckman, and all we ask is that you, as a registration fee, the only thing we ask is that you forward your invitation on to every single time to at least 3 others within your organization and to other organizations where you know other safety and health professionals or in-house counsel who are responsible for compliance with safety and health law, because spreading the word is the best insurance and protection of the future of the OSHA 3030. So please keep spreading the word every time you get an invitation. I know many of you have weighed in that you do forward on these invitations. Thank you very much for doing that. Please continue to find 3 new additional contacts to forward this on to every time. The next episode will be held on June 18th, 2025 at 1 p.m. Eastern. That's a Wednesday. We look forward to seeing you then. We have sister programs that you should know about. The TSCA 3030 and the REACH 3030. Both of them will be held on June 11th. REACH 3030 at 10 a.m. Eastern Time, U.S., and the TSCA 3030 at 1 p.m. Eastern. Excellent programs by some incredibly talented attorneys here at Keller and Heckman, and we encourage you to tune in or spread the word to your colleagues within your organization that are responsible for compliance with TSCA and REACH. Well, that's today's OSHA 3030. Thank you all for participating. Thank you, Ben Idzik, and thank you to the staff here at Keller and Heckman who helped make this program possible. We look forward to seeing you again next month. And until then, stay safe.